Hi, everyone. It's Madelena Viksne from Samfiru, Tumarkin. I'm an associate in the employment and labor group there, and I'm here for a Q&A today. To start off, I thought I would talk a little bit about a recent development, which is that Greyhound Canada is shutting down all of its operations. So there's a number of sort of issues that can come from that. The first is what happens when a company shuts down its operations. What are its employees' entitlements at that point? For all of the unionized employees, it's going to be their entitlements on termination will be determined by their collective bargaining agreement. So that is sort of already established by way of the union. In terms of employees who are not unionized, they'll be owed full severance, depending, of course, on their employment contract. If there is a termination clause in the employment contract, which is enforceable and does limit them to their Employment Standards Act minimums, then their severance will be calculated by 1 week per year of notice and 1 week including partial years of severance per year. So it would be, for example, if you worked somewhere for if you worked there for 6 years, you would get 6 weeks of notice and 6 weeks of statutory severance, assuming you've been there for 5 years or more. If there are no employment contracts, or you've worked there for long enough that your original employment contract is no longer enforceable, the termination clause there, then you would be entitled to common law reasonable notice, which is calculated as approximately a month per year. It can be 3 weeks per year. It can be sort of up to 5 weeks per year. It depends on a number of stats, including your age, your length of service, your specific position, and what the availability of similar employment is in the marketplace right now. If the company is closing permanently but is not bankrupt, whether it's Greyhound or another company, then they still have to provide severance to their employees, just as they would in a normal termination context. So if you are working for Greyhound or another company that is closing its operations not as a result of bankruptcy, then you should certainly ensure that you're receiving a termination package of some kind. And it's always a good idea before signing any termination package to have that reviewed by counsel. You can contact our office to do so. The number will be on the screen. And we can set up a consultation where we can review your termination documents and help you determine whether there are greater entitlements that you may be entitled to. Another sort of common present moment issue going on is whether the infectious disease emergency leave is going to be extended in July. At this point, it's set to expire on July 3rd, but there is the potential that they could extend it again. There's nothing that restricts them from doing so at this moment. It's also possible that they will end it in July, and then thereafter employers will be able to put employees on temporary layoffs in accordance with the common law. Now, there's probably many employees who are waiting to see if they'll be called back. You don't have to wait until July 3rd. If you'd like to schedule a consultation with our office, we can certainly review your specific situation and advise as to whether you are able to proceed to get some severance at this point so you can move on from that employer. Or if you do wait until July and then are put on a temporary layoff at that point, again, you can contact our office and we can review your specific situation. You are not able to be laid off under the common law without consent. So by not asking you for consent or not giving you any sort of option in terms of the layoff, your employer has constructively terminated your employment by changing a key term. And by doing that, you could be entitled to a severance package. So it's always a good idea if you are on layoff to follow up with counsel. You can email us at help@employmentlawyer.ca or call us at 1-855-821-5900 to set up a consultation. Now I have a question from Dina. It is, my employer is asking for proof of vaccination before allowing anyone to continue working. I work in an office, not front lines. Are they allowed to do this? This is a bit of a hot issue as well. There's no reason that your employer should require that you provide them proof of vaccination in order to return to work. This is a medical document, just like any other medical document would be. If you were, for example, going on a disability leave, they're allowed to know that your doctor requires you to be on a disability leave, but they're not entitled to information specific to your condition, except for as far as it goes into accommodation or potential restrictions that would impact your ability to work. You say continue working, so I assume up to this point you have been able to work without, you have been actively at work, and I would presume in that case that you've been employing other COVID protection protocols, such as like wearing masks, hand sanitizers, wearing masks in public spaces, or when you're, close to other employees, when you can't be physically distanced or you're not in a separate office. There's no reason that those, in our view, there's no reason that those, protocols could not continue to be employed. Whether or not you're vaccinated should not mean that all of a sudden you're no longer able to be in the workplace. So, I mean, I in my view, they shouldn't be asking you for specific proof of vaccination unless there is, some sort of a protocol in place because you work somewhere like a nursing home or a hospital where likely a mandatory vaccination policy could potentially be employed or required. However, in our view, mandatory vaccination policies by employers are not on side at this point. So I hope that answers your question, Dina. I'm just waiting for some more questions to come in, but while I'm doing that, I mentioned constructive dismissal previously. So constructive dismissal means that an employer has unilaterally changed a key term of your employment. This can be something like changing your hours, changing your schedule, demotion, change in position, or job duties that is significantly different than your previous position. In terms of hours and scheduling or pay, we generally use about a 20% sort of ballpark range to determine whether it is a strong constructive dismissal claim. That being said, it could be something like you always have worked days for years and years, and now all of a sudden you're being told you have to work overnights. Obviously, there's no percentage change in that scenario, but it would still be a significant change to the terms of your employment, the agreed terms. And in those cases, your employer can't do that unilaterally without your agreement. So those would be, again, another example of a constructive termination, which doesn't necessarily affect your pay or your hours per se, but it would potentially qualify. Constructive terminations are generally quite fact specific. But in the context of a layoff, as I was saying earlier with respect to COVID, you do have to provide your consent in order to be laid off. Whether you can really consent to a layoff such as the COVID layoffs, when a lot of those consents were given prior to the contemplation of infectious disease emergency leave, which now a lot of employers are relying on, is another sort of hot button issue. If whatever it is that you signed, if you did sign anything, refers specifically to the termination provision, to the temporary layoff provisions of the ESA. Arguably, you haven't consented to anything except for specifically those. So in any event, if you are laid off and you have not heard anything from your employer and you're not anticipating that you're going to be recalled, or you want to find out what your rights are, it's a good idea to contact our office and have us review your specific circumstances. Linda Desjarlais, sorry if I said that wrong, asked about what about bullying in the workplace. I would be helpful if you provide some more specifics in terms of what it is that you're asking. It's just a little bit difficult for me to tell from that. Do you mean what constitutes bullying in the workplace, or is there a specific scenario that you're thinking of? I'm just going to give her a second here. While I'm waiting, generally speaking, if you're an Ontario employee or a federal employee, there is occupational health and safety legislation that would apply, which prohibits harassment and bullying and workplace violence in the workplace, and gives the employer a positive obligation to ensure that bullying in the workplace is not happening. So I suppose if you do feel that you're being bullied in the workplace, the first thing to do would be to report it to HR. If it's in writing in any way, if it's nasty emails or something like that, make sure you're saving any evidence that you have. If anyone else is around, make sure you're taking note of who is present, so you have somebody you can sort of refer HR or your employer to, so that they can sort of check in and during their investigation they can get further information from other employees. But the first step would be to report it as specifically as you can in terms of what is happening, who's involved, and that should prompt the employer to conduct an investigation into your complaint. Some of the remedies can be, some sort of reprimand of that employee. There can be, things like moving you into a different role or position, or, different shifts, so that you and this employee are not interacting anymore. There's a number of sort of different solutions that your employer can come up with after they've conducted an investigation. But it's governed by the Occupational Health and Safety Act in terms of what their obligations are with respect to an investigation. So that's a good sort of first place resource to look at. You can also always contact our office and or the Ministry of Labor, either one, and they can help you sort of navigate the process. Can an employer use Alexa to drop in and listen to you? Does this require consent? I believe that this question was asked actually internally the other day. It's not clear to me from your question whether you mean on your own Alexa. Is this a workplace provided Alexa? I think you're talking about employee monitoring. I'm not sure. I've never heard of any employer doing this. If it's a policy that your employer is presenting, I would argue that it certainly has issues about, privacy rights and that type of thing, especially since Alexa can sort of be run in the background when you aren't necessarily aware that somebody is, I guess, listening in on you. I would say that I don't see how that would be a permissible way to monitor your employees, but it's not a question that I've contemplated previously. So Linda has sent another follow-up. What if you are on stress leave? Can they terminate your position? I'm assuming this refers back to the question about the bully. If you've already reported the bullying and it is the basis for your stress leave, their company should still be doing an investigation. They shouldn't be terminating you for reporting harassment. That would be reprisal, which is not allowed. So if the employer is already aware of the issue and they're taking steps and and you've requested or they've put you on a stress leave while they conduct the investigation, then you should be being kept apprised of what's happening to a limited extent. Obviously, some of it is going to be confidential and internal, but you should have an understanding of sort of where the investigation's at and what their conclusions are. You shouldn't be terminated while you're on a stress leave, especially when it's related to workplace harassment. That would be reprisal action, which means you were trying to enforce your rights under the statute, and were terminated as a result of that. It's illegal. It's not allowed. So I guess from the information that I have, the answer is no. What I would suggest to you, Linda, is that you contact our office and have sort of the specifics of your situation reviewed with somebody. I'm not sure if there's some reason why you think you might be terminated, or if there's further details that would be pertinent to the advice that you receive. So that's probably your best bet in terms of getting a more fulsome response to your questions. Okay, so just generally, I was speaking about the infectious disease emergency leave, and the fact that it is going to expire on July 3rd. Previously, so last, I think, June or July and September, there hadn't been any indication that they would be able to extend the infectious disease, that they would be able to put you on a temporary layoff after infectious disease emergency leave ended. When they moved it to January, it became more clear that they will be permitting employers to put you on layoff after that point under the ESA. At this point, we don't know whether it's going to be extended or whether layoffs will be possible at that point. But as I said previously, if you are put on a layoff or if you're on infectious disease emergency leave, you don't need to wait until it ends to enforce your rights. So now is as good a time as any to contact a lawyer and see if you can pursue severance of some kind. You can email us at help@employmentlawyer.ca or call us at 1-855-821-5900. So I have a question from Micheline Claire. Can an employer payroll department deduct time from your salary and pay out a sick day when your direct supervisor will authorize you to your hours does not submit a sick day, and you can't take a day off or sick day due to lack of staff? Sorry, this question's a little bit confusing. Can they deduct from your salary and pay it out as a sick day instead of regular wages? I guess my follow-up question here is, do you have paid sick days? So if you have paid sick days, then they're not really deducting the time off. They're just paying you the same amount that you normally would receive for a day that you aren't working. An employer should not be making deductions on your payroll in terms of you actually having losses from this. So if it's an unpaid sick day, then what you're saying is instead of being paid 5 days a week, you're being paid for 4 days a week, and they're counting one day that you are actually working as a sick day. That's not permissible. But I think what you're saying is that they're using a sick day to pay for a day that you're actually working. So they're using up your sick days without your permission, because payroll took it upon themselves to put it in without authorization. I mean, what I would do is contact payroll. It may just be an accounting error of some kind, or there's been some sort of crossed wires in terms of the instructions that they received. an employer can't really impose a sick day on you if you're actually working. So, I mean, I think that the first step would be to determine whether or not this was an error of some kind somewhere along the way. So what I would do if they refuse to give it back and you've already done that, then I would make sure that the contact that you've made with them is written, that you have it all in writing. You email them and say something like, to follow up on, if you spoke to them in person, you follow up and say, following up on our conversation the other day, I advised that I never took this sick day. We're not permitted to take sick days right now. And nevertheless, you've deducted one of my sick days from, one of my days that I actually worked as a sick day. This is not permissible. And you've refused at this point to return it. So if you put it in writing, that's helpful for you if you do decide to make a Ministry of Labor complaint. However, the Employment Standards Act does not provide for too many. I think it's only 3 paid sick days. So if you're talking about a contractual sick day, it may be something that the Ministry of Labor is not able to help you with so much. However, they do have a helpline and you can certainly call them. It will depend on whether it's a term of your contract or whether you're talking about an Employment Standards Act, one of those paid sick days that they just put out, I guess 2 or 3 weeks ago, which are only valid until September. You should be able to take time off, though. Your employer actually has an obligation to allow you and is required by the Employment Standards Act to allow you to take time off with respect to your vacation. So if you're saying that even, outside of the sick day aspect, if you wanted to take vacation right now, they're not allowed to not allow you to take vacation. They can sort of deny a vacation request if the timing is not good, but by the end of the year, you have to be able to have taken your full vacation entitlement. So, I understand the question. They took the sick day away from you. Now you can't use it. You get 3 paid sick days a year by way of the contract. And nobody submitted for these sick days. I understand that that's the issue. My recommendation is that you put everything in writing. If you spoke to them in person, send them an email, follow it up, make some kind of a paper trail, and then continue to, pursue that. They're not allowed to apply a sick day for a day that you actually worked. That's the short answer. In terms of how you can enforce whether or not they pay you or return it to you, it's a bit different. So I think the best thing to do is to create this paper trail that I'm talking about, so that, if you make a report to the Ministry of Labor, if you make a report, or if you take any other steps to pursue this, you have sort of written documentation that supports the fact that you have contested this payment. I don't know if you have sort of an online system as well that shows you how many sick days or how many vacation days you have accrued and how many you can use and how many you have used. I would take screenshots of that to sort of make sure that you have enough, that you have the evidence in case they sort of try to sneak it back in there on you, so that they can sort of alleviate their breach, if that makes sense to you. Okay, so it's a little bit slow today. Does anyone else have any questions? I have about 5 minutes. If someone has one last one. Okay, so that's it for the employment law questions and answers. This is Madelena Viksne from Samfiru, Tumarkin. And if you would like to get in touch with our office, if you have any employment questions or you would like to book a consultation, you go to employmentlawyer.ca. Our email is help@employmentlawyer.ca. And our phone number is 1-855-821-5900. If you leave a message on that line, our office will reach out to you and schedule a consultation with one of our counsel. And you can also get quick answers to your employment questions at pocketemploymentlawyer.ca, where we have a forum for you to ask questions. Okay. Thanks very much, everybody. Have a lovely weekend.